Okay. All right, great. So we are now coming back for our literary lunch. Some folks here are still noshing away, so hopefully you are as well. As I said before, we did have a change in lineup. So I will introduce Rosemary, and then she will tell you more about our fantastic speaker. So Dr. Rosemary Gray is a lecturer here at Sydney Law School. She is both a past and a future co-director of SIL. She will be coming back on mid-year when Mary goes on leave. Dr. Gray's research focuses on gender and international criminal law, particularly the prosecution of gender-based crimes in the International Criminal Court and the Extraordinary Chambers of the Courts of Cambodia. She's consulted and interned for a number of key organizations in the criminal justice field, including Amnesty International, Women's Initiative for Gender Justice, the International Bar Association, and the ICC. So I give you Dr. Gray, who will give you Associate Professor Crawford.
Inari Nalawan Mun Mari Budjuri Gadi Nurada. As Stacey said, I'm Rosemary Gray, part of this law school, and it's my pleasure to welcome you to this year's literary lunch. I just offered you an acknowledgement of country in the language of the Gadi people because we are meeting today on the beautiful Gadigal land. And continuing with the focus on Indigenous rights in this conference and building on our keynote speech by Professor Davis, our scheduled literary lunch guest this year was Wiradjuri author Tara June Winch, whose novel The Yield won a lot of prizes in 2020, including the Miles Franklin Prize. And we were delighted that Professor Crawford was able to step in when, due to unforeseen circumstances, unfortunately, Tara had to withdraw this morning, but I would really recommend her book, The Yield, to all of you. It is a really thought-provoking examination of the challenges and the joys of being an Indigenous person in Australia. And one of the most exciting features of that book, The Yield, is that it contains over 1,000 Wiradjuri words that are sprinkled into the conversation and that also form part of a dictionary that one of the characters is writing. And so it's really quite a unique book on the Australian literary landscape. It's a brilliant book, but also so is Dr. Crawford's book on non-binding norms in international humanitarian law, and obviously something that is directly relevant to the themes of this conference about international law. So Dr. Crawford's book was published this year by Oxford University Press, making it a really important book to be read because its focus is not on binding international norms, but on what is sometimes conceived of as soft international law. That is declarations and statements and aspirations that states make that don't necessarily have the same binding force as a treaty or a convention, but nonetheless, as Dr. Crawford's book shows, have a huge amount of power in many cases to shape the way that international law is understood and practiced. So we are really delighted that you were able to step into the breach, so to speak, Emily, and just that you are such a stellar contributor with your agility and your flexibility to just be generous and to share the insights of your book. We're delighted that we are hosting a reception to launch this wonderful book tonight, but this is a chance for us to dig a bit deeper into its pages. So I thought I'd start with the obvious question. Can you explain what is a non-binding international law norm? Most people here would know that, but maybe more focus on why is it important that we study and take seriously non-binding norms?
Okay, so broadly termed soft law, we know they relate to things like General Assembly resolutions or statements from international organisations. But in international humanitarian law, also known as the law of armed conflict, there's a very particular subset of soft law norms that have really kind of proliferated in the last 30 years. And they are mainly manuals of instruction that are have been put together as essentially kind of quasi-treaties. They are a whole list of rules about what law should apply to emergent or new situations. So they're to do with things like cyber warfare or warfare in outer space or air and missile warfare. And basically it came about because, you know, we all know that treaty making as a process can take forever. And you had groups of interested experts who would sort of sit around and go, no one's really doing anything about this. What if we were to put together a manual of instruction that stated what we think the law is in relation to this new field? And it started about 30 years ago with the San Remo Manual on Naval Warfare, that was done under the imprimatur of the Institute of International Humanitarian Law in San Remo. And basically it was a statement of about 150 rules or so that were a acknowledgement of what the customary law with regards to naval warfare was deemed to be. A group of around 50 experts or so got together and did it. And they were hoping it was going to be useful for state military, state navies. And it was basically fairly soon after it was published, state navies started looking at it going, yeah, this seems to make sense. And it's become basically this quasi-treaty about naval warfare, to the point where it's even cited in pleadings before courts about what is the relevant naval warfare. So using this success with the San Remo manual, there has been all of these other manuals. Like I mentioned, the Talon manual on cyber warfare, there's the Harvard manual on air and missile warfare. There are now 2 competing manuals on warfare in outer space. There's one on private military and security contractors. So basically all of these things have proliferated as a way of trying to set out the ground rules for areas of conduct or weaponry that the international law community thinks are under-regulated or kind of require a new statement on what's the applicable law.
And obviously warfare is, for devastating reasons, at the forefront of everyone's minds today with the unfolding crisis in the Ukraine and Russia's incursion. There's been allegations and credible reports both of violations of the jus ad bellum, the resort to war and aggression, in breach of the United Nations Charter, and also reports coming out of violations of IHL, that is war crimes, which is more the subject of Emily's book. Obviously, what is happening and what is reported to happen credibly in Ukraine is a violation of hard law, a violation of very, very strong binding standards, outlawing the use of force and outlawing war crimes as well. But could you also talk about what your analysis of non-binding norms might, what light that might shed on helping us make sense of the debacle in the Ukraine?
Well, I mean, as you said, it's clear that what's being broken here are the hard rules, the UN Charter. So it's very easy to be cynical about the entire situation. Say, well, if you've got states parties who are not going to respect hard law, what on earth is a soft law norm going to do? And look, there's some credence to that. It's easy to be cynical about the power of international law to do anything. But one of the interesting things to see about soft law norms, even though the book focuses on soft law norms from the last 30 years, they've been part of international law for decades. And they do have an impact. They do eventually start essentially worming their way into state practice to the point where people see it as being the rules that need to be followed. And part of the success can actually be attributed to the fact that they start out as essentially kind of this innocuous, here's what we'd like you to do. Here's what we would hope that you would do, but if you don't, no biggie. So there is the possibility that actually having them as recommended practice, or this is what we think is the way to go, gives states a little bit more room to embrace it essentially on their terms. And I mean, for anyone who studies international law, you see that there is almost always a state or group of states who resist the law because they feel that they didn't have any say in it. They're resistant to this idea of, well, we weren't at the table when the UN Charter was drafted, so why should we respect it? We weren't there when, you can go back centuries to see people who go, why should we embrace a system that was imposed by colonial oppressors, imposed by, capitalist overlords, that kind of thing. So having a system where you actually allow for, multiple stakeholders who have traditionally been excluded from the negotiation table to actually come in and go, here's what we would like, here's what we think, there is a possibility that you actually do get a little bit more of a sense of ownership, a bit more of a sense of buy-in. And research that's been done, not by me, has shown that certainly for non-state groups, the idea of feeling like they've got some sense of ownership of what's going on is often conducive to getting them to actually comply.
That's the advantage in terms of bringing a larger group of parties and non-states to the table, perhaps, is that the norms, at least initially, are non-binding.
Yeah.
Could you give us a case study of sorts from your book, because you cover a huge range of different non-binding norms and you trace their process, the way that, in your words, they worm their way into practice and state practice and become part of jurisprudence. I was wondering if you could zoom in on a particular non-binding norm and tell us who was involved in its creation, what was its path, and so that we can get a sense of how one norm has sort of gone on this journey.
Sure. To say it's my favourite example sounds sadistic, because it's sadistic to talk about warfare as having a favourite in the context of warfare. But I think one of the work that's been done by the organisation Geneva Call in relation to their advocacy with non-state armed groups has been extraordinary for actually having real world immediate impact. So their very first deed of commitment came about as a result of the work that was being done that eventually led to the creation of the treaty that banned the use of landmines. And there had been some initial discussion at the time about having non-state groups involved in the process in some way, not of course to vote, but involved in the process. That didn't really come off. So instead what happened was Geneva Call was founded to create essentially a parallel document to the Ottawa Treaty, a parallel instrument that non-state groups could sign up to and agree to commit to the terms of, to basically say, we won't use landmines. We won't use landmines, we won't buy them, we won't distribute them, we will commit to stop using them. And when this came about, I think it was 2001, I can't entirely remember when it was, half a dozen non-state armed groups signed up, and then a bit more and more did. And eventually it became their most successful, and remains their most successful deed of commitment, their most successful kind of non-state treaty, if you can call it that. And it actually does have real world impact, in the sense of part of the deed of commitment includes a commitment on behalf of the non-state group to work with Geneva Call to demine areas under their control. And Geneva Call publishes their annual reports every year, and every year they talk about how many people have gone into the field from Geneva Call and helped non-state groups destroy their mine stockpiles. And that is actually tangible proof that there is some impact from actually engaging in these kinds of activities and saying to people, here is the law, here's a way in which we can get you to behave, and here's the incentive, don't do it. And if you, part of signing up to the deed of commitment by one of the non-state groups in South Sudan actually prompted the government to sign up to the Ottawa Treaty, because they basically used it as a kind of stick to say, well, if the non-state group are agreeing to not use landmines, how embarrassing would it be for the government to go, well, we're going to still use them? So it was actually a very good manipulative tool,
bargaining tool,
a very good bargaining tool to get the state to comply.
Yeah.
So there are ways these things can work.
That would make a hell of a difference to the areas that have had the landmines removed,
yep,
and that are safer to the people there. That is a very sobering example. And I was wondering, just picking up on something you mentioned before, you were going through a range of different non-binding manuals and instruments. You mentioned the Talon manual on cyber warfare. I was interested when you mentioned that there are two competing approaches to, forgive my terminology, space warfare.
Mm-hmm.
Could you give us a sense of what is the conflict? What is the difference between the two approaches there?
There's a limit to what I can say, because I actually was part of both of them, and then I had to sign a document to say I wouldn't say anything about it beyond that.
Okay.
But the thing is, this is what I'm about to say is not actually some great secret. There is actually a schism in the space law community that deals with conflict, that is utterly divided over whether or not the part of the Moon Treaty and part of the Outer Space Treaty that talks about peaceful purposes. There are some people who take the position that peaceful purposes means no military activity at all. Mm-hmm. And there are other people say that peaceful purposes only means that you're not allowed to engage in offensive activities in outer space. So that the only thing that you're not allowed to do is position a weapon of mass destruction in orbit, and you can't put military installations on the moon. But otherwise, other military activities like military satellites or military hardware, that's perfectly okay, so long as it doesn't have an offensive purpose. And that's the big schism in military space law at the moment. And that was partially, I think, what led to the split between the two manuals.
We'll have to stay tuned, I guess, to see what prevails over the years.
Yeah, or if I get sued, we'll find out. We'll find out in the next coming weeks.
Did you find any surprises when you were researching your book? Because often we come into a field of research with a kind of at least a working hypothesis or a hunch about what we'll find. Did you come across any examples that blew you away?
Yes and no. There were some manuals that I genuinely thought were going to have more impact than they did. So, for example, the Air and Missile Warfare Manual that was done as a result of an expert group operating out of Harvard. It had many of the same experts who are involved in, would eventually go on to be involved in Tallinn, many of the experts who are involved in the San Remo Naval Manual. And I thought, surely for something that was in an area that, you know, there hasn't been, the only existing rules on aerial warfare on their own were the draft Hague rules from 1925. So surely there would be, you know, there'd be a desire to actually see this kind of written down. And when my devoted research assistant went through all of everything they could find to see if this had any impact, there just really wasn't a huge amount to suggest that it was being either repeated in state practice. It wasn't in any kind of state naval manual, military manuals. There was one mention of it in a US domestic law case in which someone was trying to figure out whether or not a projectile that had been thrown by one person against another in a domestic, basically in a domestic criminal act, could be considered a missile, and they used the Air and Missile Warfare Manual to describe a missile, but it wasn't actually in the context that counted, i.e., it wasn't in the context of an armed conflict. So I was really surprised that that hadn't had more impact. In terms of the stuff that was good to read, I mean, it was fantastic to read about the work being done by Geneva Call. And nothing else was particularly surprising, unfortunately, because there does come a point where you start to see the same patterns repeat and you go, okay, well, I mean, for instance, there was always the tension between any work that was done by the Red Cross, that it was immediately received by a certain group of people with a great deal of respect and enthusiasm, and immediately denounced by another group of people as being the work of this advocate organisation that was just trying to push their agenda. So after a while, you could kind of predict how these things were going to be received.
Yeah, and it makes it seem that perhaps if there was another type of warfare that was to start to be regulated, you can imagine those same responses would probably repeat themselves.
Correct.
Again, we'll wait and see, but your book might have a bit of that power to predict as well as being a backwards looking study.
Bless you for thinking that.
It may. We all hope our work might have that effect sometimes. I wanted to ask you if you were to give a sort of idea of what was your book's conclusion or conclusions plural, what would be the main takeaways for people to understand from your study?
Well, what I was interested about with this, because I'd been writing about non-binding norms in one way or another since my PhD, so for the last 12 or 13 years, and they'd always been kind of floating around in the background, and I'd never really kind of given them any more thought, partially because I was a junior academic and you don't have the time to think deeply about these things, but I was intrigued by the process. And then when I was asked to actually participate in the McGill manual and then the Woomera manual, I was watching what was happening. I was watching the dynamics of the group together. I was seeing how the personalities were playing out. And then it made me think of the disconnect between people in the room and the internecine fighting and kind of egos that were taking place, and then the eventual project that would come out of it. And I remember thinking, this must have been what was going on with every single one of them. And frankly, this is obviously what's going on in treaty drafting. And when you're drafting a treaty, you've got the legitimacy of the state behind you. You've got processes behind you where there is, you hope, some degree of kind of quality control. But so many of these instruments have come about because people have just appointed themselves as the person who's going to write them. And so you have a moment where you go, well, what's your agenda here, chappie? What are you trying to push? And for the most part, most of the instruments are actually very measured, sensible, statements about what the law is. There's no real attempt to try and push it too hard in any one direction. But there have been a couple of times where people have really tried to push a particular agenda. And even if they don't think they are, you have a moment where you go, well, you're coming from a large Western nation, you have a military background where you served in the field for X number of years. You currently work for a military war college. You are going to have a particular take on the law that I don't think someone who comes from a civil society background is going to have. Does that influence the way these things turn out? And I guess that was my kind of conclusion, which is the process matters as much as the outcome. You've got to be careful with who you pick to be in the room, and you've got to make sure that this is actually a project that values the work rather than the people in a weird way. It's not that the people aren't important, the people create the work, obviously, but you can have situations where the loudest voice in the room is the one that dominates, because everyone participates in these things off their own dime. We're not being paid to do this. And there is a moment where you're sitting there where one person is absolutely enforcing their view on everyone else. And you have to go, I'm not being paid to be yelled at.
Yes.
Is it this important to actually push back? And it is, because eventually this is an instrument that will come out and say, here is what you can and can't do. And my research has shown that eventually this stuff does get picked up. Sometimes it doesn't, but more of the non-binding norms have infiltrated state practice than not. So you do actually have to be really careful about who you pick to be in the room with you when you want to draft this.
I think that although you're making some distinctions between the process of treaty making and this non-binding, there are certainly overlaps about the power politics and egos and agendas, and decibel level of those in the room certainly influence the outcome. We've seen that in multiple treaty negotiations as well, even where people are paid. While the room is collecting any question that you might have, I just have one final kind of wrap-up question, and then we'll see if anyone here has something, or else perhaps if Simran could help me identify if there's been any question on the chat. I'm afraid I can't see that. My final question is more of a light one. It's about your choice of cover art. We can see displayed here. And I wanted to ask you, what is the message that you're communicating? Sometimes it can be an insightful question because it leads to a particular anecdote or a particular message that people were trying to explain. Or sometimes it's, there are a range of reasons, including publishing reasons, why we have certain covers. But could you shed any light on your cover choice?
Sure. It's a painting done by an Italian artist of Napoleon III leading his troops into Solferino. Okay. And it was the pivotal battle of the Italian reunification in 1859 that was, among other things, the kind of starter that led to the creation of the International Committee of the Red Cross. It's a very long road to get there. But basically what happened was the person who, there was a Swiss businessman who had travelled to northern Italy in the hopes of selling a business idea to Napoleon III. I'm still struck by the absurdity of someone going, so Napoleon's going to be in town because he's waging war on Solferino. I was wondering if he's got 20 minutes
for a coffee to hear my pitch.
We'll have a macchiato and we'll just talk about my business idea. While he was stationed in town, he saw all of these people kind of either being brought in or kind of stumbling in, bleeding from all of these wounds. And he was horrified that there was no systematic organisation that was looking after the wounded personnel, because the wounded personnel had just been left in the field. Basically, when the armies withdrew, they left people where they lay. And he thought, this is horrible. So he started rounding up villages, tearing up bed sheets, collecting water, going out into the field, bringing people back in. And did this basically for sort of 3 days without sleep. And he was so moved by the experience and so unsettled by it that when he got back to Geneva, he abandoned his money-making schemes and wrote this pamphlet called A Memory of Solferino, in which he said, wouldn't it be a great idea if there was some kind of neutral organisation that could provide aid to armies in the field during armed conflict? Because traditional practice had been that if your medic went to go and tend to someone, they would get shot because they were from the other side. It was just standard practice that you would shoot whoever was wearing the uniform of the enemy. And his thing was, well, what if we didn't have to do that? What if there was some organisation that could take care of it, that we all knew was neutral, that wasn't taking sides, that was just about caring for people who'd been wounded or injured or were sick in the field? And for various reasons, that got taken up, and it eventually became the International Committee of the Red Cross. And I guess you could say that it was the kind of the ultimate non-binding instrument. It was the first time someone going, hey, this is a great idea, why don't we try it? And it was through his advocacy, basically, that states in Europe thought, not a bad idea, took it on, and then it actually became the force it is today.
Yeah, it absolutely laid the groundwork for international humanitarian law, from that war crimes law, or different standards that are certainly enforceable as hard law today. Is there any final question from the room about this study that Emily has conducted, or is there any question on the chat? Yes, please, go ahead.
Yeah, I was just focusing. Thank you, Professor Crawford, for your contribution. So I was just wondering a few kind of confusing points that have haunted me for quite a long period of time. So we've talked about examples like invasion or like intrusions between states, sovereign states, widely recognized. But I was wondering if there has been any sort of previous experience where the hard law outlining our humanitarian obligations were deemed as inapplicable. And a real thought is that, for example, in the case of Russia invading Ukraine, we have a clear-cut breach on the UN Convention. But what if, in another sense, what if we have China invading Taiwan? Because Taiwan is not a widely recognized sovereign state. There's no and the Chinese narratives have always been it's an internal squabble, it's a civil war sort of matter, but there has been a lot of international concerns over here. So would it be would that be the case in which hard laws are being excluded, and we have to rely on sorts of non-binding norms to sort of at least just analyze the situation there, because not necessarily going to change the minds of the Chinese authorities?
Yeah, look, I mean, like I said right at the beginning, it's easy to be cynical about international law and its ability to actually affect change. I think that's because this is gut, not research. From my 10 years of teaching in the field, I found that students want international law to do what no legal order has ever done ever, which is always work and always work perfectly. And when it doesn't, it's very kind of, well, it doesn't work, and so therefore we shouldn't have it. So I think people approach international law, cynics approach international law in a way that they wouldn't necessarily approach domestic law. I don't think anyone goes into a domestic law system and go, well, you know, that person got acquitted because there wasn't enough evidence. Oh, the system's broken, it's never going to work, let's throw it all out. Whereas they do with international law. So when you see a state clearly violating international law, like Russia is doing with Ukraine, like the US did going into Iraq, like they did in Guantanamo Bay with torturing prisoners, it is easy to kind of just go, well, then the system isn't working. The thing about cynicism is it's a very easy position to take, because it doesn't require any effort. Believing in a system requires effort, and it also requires buy-in, that you've got to actually work to make it work. So I think that the complexities of the world require as many approaches to try and get things to work as possible. And that includes hard law, it includes soft law, it includes diplomacy, and all the different kinds of methods that you can to try and make something work. The big difference between what's happening in Ukraine and what's happening with Taiwan is that at no point has China ever said that it thinks Taiwan is a sovereign nation, but Russia said Ukraine is a sovereign nation. That Russia recognized Ukraine as a sovereign nation in 1991. So there is a big difference there. I'm not going to get into the complexities, because it's a very difficult and messy situation. But yeah, I think you have to call on all of your you have to corral all of your resources to try and deal with any given situation in international law, because it's so complex.
Could you speak with more volume?
So just
Thank you.
So just a supplementary point there. So like even if we cast aside the enforcement or some sort of implementation side of the question aside, just wondering if there's a, like, just technically speaking, if in that kind of situation where we have a strong argument in favor of disregarding hard laws of treaties because they don't apply, they may not apply, would you consider that these non-binding norms would take a greater significance over the
well, look, the first thing I'd say is that there is no, that if we're talking about Ukraine, there is no question of there being an exception or it not applying. I know that Putin's attempting to argue that there's a humanitarian intervention angle to what he's doing, but that's exceptionally dodgy. But I think yes, that if you are in a situation where you have people who are not going to follow the rules, you do try and find ways in which you can kind of coax them back into compliance. And often regimes that don't necessarily have things like sanctions might be a way of doing it. The problem with that is that's deeply unsatisfactory. It's deeply unsatisfactory to look at someone genuinely, clearly, blatantly law-breaking and go, let's try and treat them nicely and kind of nudge them towards the direction of compliance. So I get how unsatisfactory and how frustrating that is. And unfortunately, I have no simple answer for that beyond just, you just got to keep trying, because what's the other solution is giving up. And I don't think that's the solution at all.
Thank you for your questions. We have two from the chat, and the first is from Natalie Klein. And it's a sort of a two-part question, but they're all related. She asks, what do you consider the difference, if any, where non-binding norms are adopted by private experts, as occurred with the San Remo manual, compared to non-binding norms that are adopted by states?
Okay.
Maybe take that one and then I'll go to her next question. Yeah.
I really wish I could find out who's actually on the Zoom, because I don't want to be putting anyone offside. But from my experience when I was doing the Uluru manual was that everyone kind of knew everyone else, and they'd known one another because they've all moved in the same circles for the last 20 or 30 years. Now, this doesn't say anything about the quality of the output. These are all experts. They're all excellent, but there is a moment of you do get a sense that there is the potential, if not the actuality, the potential for the knowledge to be a little bit siloed. It's a little bit siloed because everyone kind of knows each other, and they've all kind of hung out before, and they've all gone to the same conferences, and they all sort of think the same way. So with expert processes that lead to a manual, there might be an element of it being a bit more partisan, if I could use that terminology. Possibly, doesn't always happen. And with expert groups, say for instance, under the guidance of somewhere like the International Committee of the Red Cross, you are absolutely going to get a very particular perspective. I mean, that perspective is a good one. It's a humanitarian law perspective, but it is something that's may not necessarily be the same kind of take on a situation that, say, experts from West Point are going to have.
Yeah.
The difference with the ones that have been started by states has often been that they are much more aware of basically their own inherent legitimacy to be lawmakers. So there's less of a sense of having to make sure that everyone's in agreement, or that they are canvassing all opinions. So that you see that with the expert groups, there has been historically much more sense of, we need to try and make sure that we have representation. We need to make sure that we've got enough different experts from different parts of the world to kind of come in and have a look at the issue. Whereas the processes that have been done by states, there just seems to be a little bit more of an automatic acceptance with it. So like with the Montreux document on private military and security contractors, every single country in the world that used PMSCs were essentially on board right from the get-go. So there was less of a requirement to have to kind of convince states of the importance of it.
Yeah, that makes sense, that they had that extra persuasive burden when it comes from private actors before they persuading about the legitimacy of the instrument at all, let alone the rules within it. Natalie's question continues, quite an astute question. She says, you mentioned, and I also asked you about the competing manuals for space. Her question is, so what is the significance of competition between non-binding norms for international law where there is conflict? What do we do with that conflict? And related to that, what is the international law significance when non-binding norms are updated? And she has an example of current updates to the San Remo manual by 2 different groups. So how do we deal with competition between different non-binding standards and updates to non-binding standards?
To the best of my knowledge, and my knowledge isn't that best, is that the 2 manuals on the law of armed conflict in outer space are the first instance of competing manuals on the same topic. Neither of them have been published yet because they've been held up by the pandemic. The idea had been they were going to be, both were going to be coming out like 2020. So there's been a hold up in that respect. So it will be really interesting to when they both come out to compare and contrast, because they're dealing with the same things. They're dealing with exactly the same things. The scope is pretty much exactly the same. It'll be fascinating to see how both expert groups have formulated their rules on the exact same topic. So what does Woomera think the rule of proportionality is in comparison to the McGill manual? I'm sorry, my brain's gone completely blank. Second question, updates. Yeah, so that's been the other thing that I think there has been a real push to make sure that these instruments are updated with some degree of regularity to make sure that they stay relevant, that they basically stay current. I think partially because there is an awareness of just how difficult it is to get the damn thing together in the first place. The San Remo manual took, I think, 5 or 6 years, and to corral that number of experts at the time, it was in the same room, all having done their research, all talking about the same stuff, all ready to do it. Is a really difficult undertaking. And so if you've got something where you've already got the document that you can work on it and then just go, okay, let's read Rule 42. Rule 42 says this. Do we think this is still, relevant given change in state practice? Yep, cool, moving on. Rather than actually having to write it from scratch. I mean, as someone who had to write and rewrite the rules that I wrote for Woomera, yep, it'd be much better to be working on a draft than actually having to get something from scratch.
Same with all writing. I find myself I much prefer to edit and update rather than start with that blank screen. And unless there's one final question in the room, we might, there's 2. Let's switch to the room then. Gentlemen up the front first and then we'll go up the back.
Hi, Emily. Just prefacing this, I'm asking this in my personal capacity and not in my capacity as a DFAT representative. 2 questions. One on sanctions. Is there any reference in your book to IHL carve-outs for sanctions being either binding or non-binding, or any consideration of sanctions at all in the IHL context?
No, I didn't have the time to look at that.
That's right. And just secondly, in terms of like a measure between binding and non-binding, how do you kind of, do you purely see it in like a formal hard law treaty context, or, because I know Australia obviously has a treaty and a less than treaty status, so it's I guess easier in that context, but it might not be in some other nation states. So I'd be interested to see, or hear rather, how you came to the non-binding conclusion. Yeah,
so the whole first chapter basically looks at all of the different ways that you can define something as being non-binding, and I mean, there's a huge amount of literature on the idea of soft law, and you basically take the binding treaty as the starting point, and then you start kind of whittling away to include things like soft law provisions in binding treaties, to agreements that might be enforceable but are of less than treaty status, and basically the whole way down. And I think what I eventually ended up settling on was the definition that Christine Chinkin came up with. No, not Christine Chinkin. Was it Christine Chinkin or Dinah Shelton? Possibly both. They were both kind of fairly similar, and they basically came up with this idea of, look, we're defining non-binding as anything that has no ramifications that kind of follow from a failure to observe the terms. Like, that's all we're looking at. I mean, of course, there are some commonalities. We're looking at something that's been put in written form. We're looking at something that is involving more than just one person writing it, often involving a group of people getting together. But in order to make my definition as broad as possible, specifically to incorporate all of the IHL instruments I was wanting to look at, I basically wanted to go as broad as I could, because I do actually look at 2 provisions in the Geneva Conventions, actually one in Common Article 3 and one in Additional Protocol 2, both of which are soft law norms in a hard treaty. And I wanted to look at whether or not the inclusion of a soft law norm in a hard treaty did anything to change its impact. The spoiler alert, it doesn't. But I wanted the definition to be as broad as possible. And so basically I took the position of, for the purposes of this book, a non-binding norm is anything for which there is no consequence that applies at international law for a failure to observe its terms.
What is the example in the Common Article 3?
In Common Article 3, right at the very end, the article says parties to the high contracting parties and parties to the conflict, I'm paraphrasing here, are encouraged to engage in special agreements to bring in some or all of the provisions of the Geneva Conventions between them. It was their way of saying, look, we're not going to make you do it, but it would be awesome if you could actually agree to apply the Geneva Conventions in part or in total. And some states did. There are a ton of examples of states going, yeah, you know what, okay, we will. Disappointingly, I shouldn't laugh because it's macabre, but disappointingly, one of the absolute examples of special agreements between states happened during the Balkan Wars, where basically the non-state groups fighting one another in the Balkans agreed to apply the Geneva Conventions. They had signed documents that said they were going to do it, and we know how that turned out.
Thanks.
Last question?
There's one last question, because just before this gentleman asked it, I'll just acknowledge this question in the chat from Sam Hussein, which is how are private agencies involved in developing non-binding norms, if at all? And thank you, Mr. Hussein, for that question. I think that's already been largely answered in response to the question about the difference between private versus state. So thank you for the question, Sam. And then finally, we'll end with this gentleman's question up the back before I say thank you to Emily.
Thanks very much, Emily. One of the risks of conflict is the spread of disease, right? And it's in everyone's interest that that doesn't happen. Is there a public health dimension to these manuals, or is that already dealt with in hard law or in other ways?
Usually what happens is almost all of the manuals just deal with the hard law with relation to IHL. But what we've started to see is an expansion of an acknowledgement that these things can no longer be contained and that there are going to be what are called reverberating effects. Now, admittedly, reverberating effects has a very specific definition in the context of IHL, but there is an increasing awareness that, yes, there are going to be flow-on effects that are themselves going to be problematic. That tends to get dealt with more by people who work in the area of things like disaster law. The IHL manuals tend to kind of stick to their lane, I think partially because the biggest criticism that you can level at a non-binding norm that's been done by an expert group is, well, who gave you the right to write this? Who gave you 30 experts the right to sit in a room and tell us this is what we're going to do? So there is a reluctance, I think, to venture too far out of their lane into something that might be seen as, well, that's not technically an IHL issue, so we don't need to worry. And the example of where that happened, even when it kind of was in their lane, was the absolute chaos that took place with regards to the ICRC direct participation and hostilities guidance, which is that the ICRC said, okay, well, here are our rules on direct participation, but we're also going to include a section about the limitations on the use of force, like the force that can be applied when you're engaging in actions against persons who are DPH. And a third of the experts who were involved in the DPH process said, that's not for you to say. All we're talking about is DPH. You're not to tell us the limits of force that we're allowed to use against people we're allowed to legitimately target. That's not within your remit. And if you don't remove it, we're out. And they did. A third of the experts removed themselves from the process because they felt that the ICRC was overstepping its boundaries, including that in the DPH guidance. So I think you see a very similar thing, which is that a group of IHL experts obviously are going to be aware of the public health implications of bombing a dam or accidental poisoning of a river or destruction of crops. I mean, all of those are actually rules in hard law, in the Geneva Conventions and the protocols. But I think you'd find that there'd be experts incredibly reluctant to actually come out and say that a precaution in attack has to be an awareness of ongoing health implications of what you're doing. It's changing. you're starting to see some discussion about the idea of that in engaging in targeting activities, you actually have to be aware of the possible reverberating effects for mental health. That's becoming an increasing area of concern for people. And so it'll be interesting to watch over the next 10, 20 years, whether you start sort of saying it's no longer a matter of that when you attack, you just blow up a building. There's more and it continues, and that has to be part of the quantum.
Thank you for that insightful question. Well, we'll end this session there, which gives us time for about 10 minutes for people to have a cup of tea in this room or at home before we reconvene at 12:30 for our next session, which is about private international law. But I just wanted to say that although we would welcome our scheduled author, Tara June Winch, another time, it was a silver lining that we had the opportunity to hear about Dr. Crawford's book, because as you can see from the discussion in the room, it is a hugely researched book, and I think it sheds light on an area of international law which has a lot more potency than it's often given power and given credit for having. So thank you for speaking with us and stepping in so expertly. Thank you to everybody.